A landmark class action lawsuit in Ohio has inspired critical changes in their juvenile justice system.
What we did find, the lasting impression, was the amount of verbal and physical violence that was open and naked. 280-pound officers, face to face, right in front of us. And they knew we were investigating, screaming and yelling and calling these girls bitches and whores. The presence of a culture of violence where you hit first and ask questions later. Now, nobody mounted as such, but that's what we saw.
When they were injured, and we're talking, broken bones and sexually molested.
A shoulder broken, a wrist broken.
The young girl had been beaten so severely against a wall she lost hearing.
I remember interviewing one kid who had none of his upper teeth. And then when you trace the incident back, in many of these cases, maybe most, no force at all should have been used. It should have been a verbal de-escalation.
DYS institutions were wildly overcrowded with kids who never should have been placed there to begin with.
Our addiction to incarceration.
At that time, to the extent they were getting education services, what was happening was that students were getting worksheets passed under the door.
We are locking kids down 23 hours a day.
I talked to a young man who had been locked down 3 consecutive months in a special management unit cell that was smaller and less amenable than the Supermax prison for adults.
For those kids that are subjected to that, it is absolutely dehumanizing.
All these things were noxious and ran counter to any efforts to create an environment where rehabilitation was possible.
And we say, well, where's the rehabilitation? How are we trying to change Johnny? Well, we're not trying to change Johnny, we're trying to punish Johnny. But Johnny is an immature, undeveloped kid.
Not unlike many other states, conditions reached a tipping point in Ohio's juvenile justice facilities.
These were very serious situations, and the system needed to start over with a new philosophy.
As a result of these findings, the Ohio Department of Youth Services settled a federal class action lawsuit which became known as the SH case.
Both parties, the state and the council, accepted my report as the basis for fashioning an agreement.
They concluded objectively that the entire system was unconstitutional, that there was cruel and unusual the way the youth were being treated. We locked ourselves up for several months negotiating the way to fix this problem. Came up with the document, which is the settlement agreement in SH. Judge Marbley brought that same expert team in, and Mr. Cohen testified in court, and we brought members of the class, some parents and some youth that had been incarcerated. And we described the problem, we described how the settlement agreement solved the problem, and asked the court to approve it for implementation. Judge Marbley did that. He declared from the bench that this was a crisis, that it was a serious problem, and that he wanted it remedied as rapidly as possible. So those were our marching orders.
This was a system that had been made to look like an adult prison system. Eventually, the case was expanded to include all of the facilities because we realized it needed to be overhauled from the top down.
The SH case is part of a larger category of judicially stimulated reform, referred to as institutional reform litigation, which leads not to an exchange of money, but to court-ordered, then often court-supervised, change.
With the changes that we're trying to implement through SH, Ohio has the opportunity to be a leader. The document itself describes the most progressive, inspiring, philosophically appropriate way to address juvenile justice in the country.
It's the broad-based reform of internal conditions, making them safe places with the best rehab you can get as we move into the community and establish a whole different identity for this agency.
So much of what people focus on, especially when you're learning to be a lawyer, is establishing liability. But the real work is remedy. And you have to get to remedy. You have to work backwards in all your strategizing from where you want this to end up. This gets back to the fact that corrections professionals actually want to do the right thing, but rarely are given enough money to do the right thing. So lawsuits help them fund the right thing.
Our system, this broken system that we talked about, wants to believe that as long as they know the difference between right and wrong, that that's enough. And it really isn't. It begins the discussion.
As Ohio moves forward with implementing the changes described in the SH litigation, we spoke with some people who work with the youths in the system about what works best, what a model, effective system looks like.
I think what I'd like to focus on is what a good post-dispositional system ought to look like, because I think that once kids get committed, it's sort of out of sight, out of mind, and so I don't think we have a good common vision about what the objectives of that system are and what it ought to look like. So I think that there are three things that are really critical. One is that by virtue of the fact that these are kids, they don't lose their constitutional rights, they don't lose their civil liberties, and they should be afforded a good system of legal protections once they're incarcerated and once they're back into the community. Those kids that are incarcerated and out of the community for 6 months or 12 months or 18 months or 3 or 4 years are not really on their radar screen.
We're always looking for more ways and better ways to be able to represent these youth the best way possible. It still strikes me how polite they are when we talk to them. I don't know if it's because they know we're there to help them or answer their questions, but they're incredibly polite. They'll accidentally swear and apologize. They'll call you ma'am or Miss Jill, or and they're so dear. I mean, they really are, and I think there are many times when these kids are portrayed as lost causes or monsters or undeserving of our attention. But really, if you go to one of these facilities and you're on unit, what you see is a group of kids. Historically, there's been a lot of resistance from allowing youth to have legal representation in any administrative process.
There needs to be access to lawyers for conditions of confinement issues. There should also be a built-in judicial oversight piece to that, so that a lawyer can bring that case back before a judge for a review if it appears that the child is being unnecessarily detained for a long period of time. And so those are the kinds of things that lawyers can do. They can also certainly assist in securing that child's release and helping with some of the legal barriers that they encounter back in the community on reentry.
Right. So things have changed since we've started coming out here. Mm-hmm.
So it's a great opportunity to be an advocate for a child and to show them that not everyone is sort of out to get them or, against them or wanting them to fail or giving up on them. The perfect juvenile justice system would remain separate from the adult criminal system, first and foremost. The whole adult crime, adult time thing it's a saying, it's a political statement, but it's not true, and it doesn't work. All it does is turn out more and worse criminals. We also need to make sure that kids' rights are protected when they go to court. They need to be represented by counsel. They need to be afforded due process rights. The juvenile justice system is only going to work if both sides are represented. You can't have a strong prosecutor's office and up against a 14-year-old who doesn't understand the court proceedings. It results in unfairness, and it results in bad outcomes for kids. So kids need strong advocates. In Ohio, right to counsel is something we have focused a great deal of time and energy on. They may feel like they have to waive their counsel because they want to get this over with, because they're in trouble, and they certainly don't want to make it longer process than they need to. And so children tend to be very quick to waive away their rights, and sometimes in an effort to please the court, so to speak, so that maybe the judge will go easier on them. Certainly, the high waiver rate of counsel is something that we've tried to address here in this office.
I think a second objective that a good system ought to have is that it looks at keeping kids out of the system that don't need to be there.
I think the nice part about the university and what I do is that we're in the field. We're not working in an office, but we're actually trying to change young people or change the system to help young people's lives. And so I think that's the really important piece. I see my role is to influence what happens to kids as they move through the system. And so one of the things that I think the risk assessment does and the new footprint for Ohio really does is it helps step down those kids, either keeps them out and doesn't allow them to penetrate deeper, or also helps them get released quicker. Those kids who really do not need that high end of a resource.
I think it's a mistake to think about working with kids in the community once they're in trouble. I mean, I'm a true believer that the earlier you can intervene with kids when they're still making good decisions and reinforce those and have positive activities for them to do at a young age, the less likely it is that they're going to be involved in the juvenile system down the road.
The more we can do at home, the better off we are. Because as soon as we start doing it in the institutions, we've taken 10 steps backwards.
I think the police could play a big role in the change in the juvenile justice system because we see them first, along with teachers. Teachers see them and we see them. And we can direct them into more productive pursuits. I would hope that a juvenile justice system that I would design would be built on having these programs available in neighborhoods on the front end, increasing those opportunities for athletics, for art, for extracurricular activities.